Hello, my name is Muhammad Ibrar. My UHID 240607775. I will tell about the introduction. In this problem, we are advising Suleiman, the owner of the Haveli House restaurant, on his right and remedies against Amjar Furniture store under the sale of Good Night 1979. This is a business to business B2B contract for the sale of goods. Main questions to be answered is whether Amjad Furniture Store has breached the implied terms under the Act of Particularly. Regarding the tables, the chair and the sofas and wood remedies are available to Suleiman. The tables, we will again begin with the table. Suleiman ordered 25 extra large marble tables in grey. What we received was a mixed delivery of 10 medium-sized marble tables, 9 wooden tables, and only 1 extra large marble table in grey. This clearly raises an issues under section 13 of SOGA, which deals with goods sold by description. Where there is a contract for the sale of good by description, the good supplied must match what description. Here the description was 25 extra large marble table in grey. Medium tables and wooden tables do not match that description at all. In the case of a cross limited Renaissance and Sons, even a small difference in the size of more serious. Both size and material are wrong for most of the tables. The amounts to be a breach of condition under section 13. Because this is a breach of a condition, Suleiman is entitled to reject the non-conforming table and treat the contract as a reputed in the relation of the those goods. And there is also problem with quantity. Only 20 tables were delivered, not be 25. There was an order as section 13 of SOGA deals with a short of delivery. It gives the buyer a choice. He can reject the whole delivery or accept what has been delivered and claim damages for the missing amount. He is here because the quantity is short and most of the tables that did arrive do not match the agreed description. Suleiman Strong's position is to reject the table a whole and claim his money back and or damages for the failure of the supply what he ordered. The chairs next will look at the chair. Suleiman ordered 100 velvet chair which were at display and reduced by 50%. Someone told him what is a part of the some miniature and wear and a chair. The chair were in good condition. When the chair arrived, Suleiman opened on box and noticed that a couple of chair and grace marks of the on the back and some and scratches of the bottom. This brings us to section 14 of SOGA, which implies a terms that goods supplied in the course of the business must of the satisfactory quality. The act explains that this means what a reasonable person would regard a satisfactory, taking into account the descriptions, the price and all other relevant circumstances. Because these chairs were at display and half price somewhere and there is a to be expected. However, grace marks on the back of chair and are going to be used in a restaurant. My voice has been going beyond acceptable minor wear. A reasonable restaurant owner would be more acceptable because there might not be a visible, but marks on the visible surface are are harder to justify. The test is objective, not about what Suleiman personally thinks, but an ordinary reasonable buyer in his position would think is structured in case of such as a just and limited breach of section 14(2), which like section 13 is treated as a condition is in a business sale. In that case, Suleiman would be entitled to reject the chair. On the other hand, if the court sees the difficulties of the minor and exactly what you would and expect on cheap and display terms, it mightly decide insisted and in the situation. Suleiman would not be able to reject all the chair, but he could still claim damages for price reduction, reflect the facts of chair of were not in the expected condition. The sofa most serious issues involves the sofa where Suleiman explicitly reached by quality buyer or rotation for the skin condition. Suleiman made now the particular purpose for which the sofa was being bought use people including those with skin condition and relied on someone skin and judgment someone reached him the leather was of the highest quality and there would be no issue. Suleiman relied on the resource and of the deciding to buy. The fact that Suleiman's daughter developed a red blotchy rush suggests of the sofa is not fit to its particular purpose. This is a breach of a condition under section 13. Under section 14(3) SOGA. Safety also forms part of satisfactory quality under section 14(2) and a sofa and cause a rush when an use normally is neither safe of a satisfactory. Suleiman is therefore entitled to reject the sofa and recover the price. In condition, he can claim damages for consequential loss. That is loss following from the breach under the general rule of the hardly extended off to my recover losses that arises naturally from the breach or which parties could responsibly but for sins and this cans could include the reasonable cost of medical treatment for his daughter and any financial loss caused by having or remove the replace of sofa. Acceptables and the conclusions. Finally, most consider whether as Amjar Furniture Store claim it is too late to cancel the order and Suleiman must accept the good and pay. We must assess if Suleiman has accepted to the goods under section 35 of SOGA. Acceptance is deemed to the taken of the place of the player of the immediate accepts when of the goods are delivered and used of the reasonable times or when the buyer acts is away inconsistent with the seller ownership. Crucially, section 35(4) states a buyer is not deemed to have accepted goods merely because they have been delivered and not rejected. Section 35(6) provides that a buyer does not lose the rights of rejected till have had a reasonable opportunity to examine them accepting of they conform to the contract. Suleiman due to his busy schedule only examined the example. The sample of the chairs and used of sofa on the evening of delivery. The next day he contracted the store given the volume of the goods 25 tables, 100 chairs and the fact of the discovered the faults and reached the rejection within 1 day of the good arrive. It a highly likely courts of wood of the has not had a reasonable time to examine and therefore are not accepted to the goals. Conclusion and remedies. In summary, Suleiman has strong legal grounds. The purpose of the claim against Amjad Furniture Store he has the right to the confirming goods